Good morning, family. Today, it's a boring real estate school day. We have to read pages 287 to 323. We, of course, are not going to read all of them, but we're going to try to read, we're going to get through some of it. We're going to drudge through the mush together. Today, I'm wearing my Rubik's Cube shirt, so it looks like I took like 5 in the chest. All right, 6 in the chest. Oh, you know what? We've got our Spanish translation going right now without having started the Spanish translation. So we're going to go and kick that off right now. Thank you for reminding me there, Andres. If you are tuning in right now on Facebook and you would like to have this translated live into Spanish, we have this happen every single day. Andres de Arense translates these classes Monday through Friday, 9 to 10. When he can't do it like tomorrow, Christian Tikas covers for him. So we want to make sure that everyone is getting licensed who wants to get licensed. We want to get everyone involved. So shout out to Andre, always passionately translating this into Spanish, even when I talk about how boring it is, like it is today, and I do to try to wake up. I get to hear what that sounds like in Spanish from the other room. All right, so today's day 13. We're jumping into chapter 43. Trespass, a violation of easement. Chapter 44, nuisance, offensive interference. Chapter 45, boundary disputes. Chapter 46, deeded as transfer. If you are so lucky and we're still there in chapter 47, grant deed versus quitclaim deeds. Chapter 48, delivery, acceptance of deeds. And like I said, pages 287 to 323. I feel like I need to write that one down so I don't have to keep bouncing back and forth like I normally do. 323, remind me, Aim, when I am asking you as we're sludging through the trenches together, how many more pages we have to read, just say more. Okay, and then of course, every day after this is Commission Boot Camp. Amy Serpa is here pretty much every day. She hasn't missed a single one yet. And we are helping people who are unlicensed to generate leads as finders for commission in our Commission Boot Camp. So join us every single day, Monday through Friday, starting at 10 o'clock. You could open your laptop or you could come in here to the office. We already have Lika in here, of course. And Lika brought his friend Michael. And it is innovative every day. It is energetic every day. We've got a lot of good things going. So come out and be a part of it. We'd love to have you. All right, I'm putting it off, Amy. I don't want to do this. Oh, here we go. Trespass, a violation of possession. Ugh. I even put the boring day emoticons down here. That way, if you are so unlucky as to stumble into this on the very first day, you'll know it is a boring day. Okay, here we go. This is chapter 43. This is out of the book Real Estate Principles. We are diving deep into all of the boring stuff every single day so that you get an opportunity to learn. And really quick, actually, a big congratulations to our first licensed agent, James, out of the high school course. He's been studying with us since day one. He had already been engaged in this. We helped him, helped him to learn. He was there every single day, and along with his dad, who's a high school teacher, and they both passed their license test yesterday. So we have two brand new. Hey, all right, we got some clapping going on in the office. Two brand new agents right here at our community that are going to be operating out of Temecula. So keep your eye out for James and Fred, a father-son real estate team that is newly licensed and ready to go. Daniel, welcome to the office. I told you the office is filling up. Okay, it's boring stuff. Here we go. Trespass, chapter 43. Shout out to Amy Serpa who read the boring stuff yesterday. Okay, ejectment, liabilities, and title risks. A trespass is any wrongful and unauthorized entry onto real estate in the possession of another. Thus, a trespass is fundamentally an interference with another's possession of real estate. It is distinct from any interference with title or an ownership interest. Anyone in possession of the property, such as the fee owner, a life estate owner, a tenant, or even a person in wrongful possession, has the right to stop a trespass. A fee owner can even trespass on the property they own. They own in a fee simple when the property is in legal possession of another person, such as a tenant. Trespasser liability for harm done. When an entry is not privileged, it is considered a trespass. A trespasser incurs civil liability for the monetary amount of any losses or injury they cause to the occupant's person, real estate, or personal property. Conversely, damage to the fee owner's property caused by the person who is in rightful possession, such as a tenant, is not a trespass. If the damage caused by someone in rightful possession constitutes waste, since they have impaired the property's value. Isn't this exciting? I told you this was going to be an exciting day. Are people already falling asleep? We have 4 poor souls who've tuned in to real estate school on the most boring day. Here we go. It's Tuesday through Thursday, which means that it's boring real estate school time. An owner may bring an action for trespass against a trespasser, even when the trespasser caused no actual injury by his presence in the owner's property. If no injury has occurred, the owner may only recover a nominal money loss from the trespasser. Nominal money losses are rewarded when a wrong has taken place but has not resulted in a money loss. To recover actual money losses for a trespass, a rightful occupant needs to sustain a real actual loss. Actual money losses recoverable for a trespass are based on injury to the real estate, lost use of the property, personal injury, and injury to the occupant's property, personal property, Indirect trespass. A trespasser does not require the trespasser's direct physical presence on the property. A trespass can result from an indirect entry into another's property, sometimes called trespass on the case. For example, one can be liable on a trespass for losses caused by activities such as depositing dirt or debris on another's property, leaving toxic waste on another's property, leaving personal property on real estate belonging to another, diverting a river or surface water across another's property, starting a fire and negligently allowing the fire to move onto a neighbor's property, or allowing one's animal to wander across another's property. Injunction to abate a trespass. Besides a recovery of money losses, an owner can obtain a court-ordered injunction to stop a person who is a continuing trespasser. A single isolated trespass is not a basis for an injunction. However, if seeking money losses would not prevent a trespass from being repeated in the future, the rightful occupant can obtain an injunction against the trespasser. Criminal trespass on the refusal to leave. In addition to liability for property damages, a trespasser may also incur criminal liability. Trespassing becomes a misdemeanor when the trespasser refuses to leave the property on foot or in a vehicle when requested by the owner's agent, a person in lawful possession of the property, or a law enforcement officer acting on the request from a person entitled to possession. Enters and occupies the property without the rightful owner's consent, refuses to leave a transient occupancy establishment, hotel, motel, vacation property, on the request of the owner or manager, enters a property dwelling, or enters industrial property such as an oil field, a gas or electric plant, or a railroad yard where posted signs forbid trespassing. A crime is not committed by merely entering into another's property except when the property is a private residence or posted industrial property. Removing trespassers by ejectment. That sounds violent. This is something they're actually starting to Uberize, which is starting to freak a lot of people out. Anyway, look at Uberized evictions, and that's where we're heading in this post-apocalyptic world. Here we go. Removing trespassers by ejectment. An owner's first course of action when confronted with a trespasser is to simply request the trespasser leave. If the trespasser does not leave when requested, they commit a misdemeanor. An owner may not forcibly eject a trespasser to discourage disturbances of the peace caused by self-help. California law allows both tenants and trespassers to recover losses from landlord or property owners for forcible entry and detainer. A forcible interference with an individual's peaceful possession of a property, even if that individual's possession is wrongful. An owner may only recover possession of their property from a trespasser through a court action, except when the trespasser is a transient occupant who failed to depart as agreed. The type of action brought to recover property depends on the type of possession held in the property. For example, The action to recover possession of a property from a tenant on default on their lease obligations is referred to as an unlawful detainer, or UD. In the case of a trespasser occupying property, the legal remedy is an ejectment action. Ejectment is similar to a UD action, but has less stringent proof of trespass requirements. The trespasser in an ejectment action, unlike the tenant in a UD action, never had legal possession of the property for an owner to have the trespasser legally removed. In an action to eject a trespasser, an owner or other occupant needs to prove they have a superior right to possession of the property. The owner may then obtain a court order for the removal of the trespasser from their property, called a writ of possession. The court order is carried out by the sheriff, not the owner. Adverse possession and intention. Inattention, excuse me. A trespasser who occupies property without the consent of the owner can be ejected by a court order at any time and charged with a misdemeanor. However, a trespasser can acquire title to the entire property by an adverse possession if they can maintain exclusive possession of the property as a trespasser for a period of 5 years. To establish title by adverse possession, the trespasser possession needs to be open and known to the owner, and the trespasser is to pay for all property taxes. Okay, chapter 44. Nuisance, offensive, unhealthful, or obstructive. Interference with use and enjoyment. A nuisance is anything which is offensive to the senses, is injurious to the health, or obstructs the use of property. Simply, a nuisance is any activity which interferes with an owner's use and enjoyment of their property, including conditions which are unhealthy or offensive to the senses. A nuisance is broadly interpreted to encompass a wide variety of activities. Nuisance, per se by statute. I don't know what that I get exposed regularly for not knowing how to read all these crazy things. Here we go. An activity becomes a nuisance based on either a statutory provision identifying conduct that is a nuisance per se, or a balancing of the conflicting rights and interests of the neighboring property owners. A nuisance per se is any activity specifically declared by statute to be a nuisance. If an activity is a statutory nuisance, it can be ordered stopped by a court without proof, or it is harmful or offensive effect. The list of nuisances per se is wide and diverse, including fences of excessive height, unnecessarily exceeding 10 feet, called spike fences, the illegal sale of controlled substances, fire hazards, and swimming pools which do not comply with statutory health and safety standards. Conversely, some activities are declared by statute not to be nuisances. Activities done or maintained under the express authority of statute, called statutory authority, cannot be nuisances. For example, the activities of commercial agricultural processing plants are maintained under statutory authority and cannot constitute a nuisance. It's a good thing I didn't show up to work drunk today. Holy smokes. I'm just kidding. I don't like to drink alcohol. It's not my thing. All right, balancing rights, inconvenient or improper. To determine whether a nuisance exists, whether an activity is not classified as a nuisance per se, a balancing of rights for a neighboring property owner is applied. Every owner is entitled to use their property for any lawful purpose. However, an owner is limited in their conduct since their permitted use may not unreasonably interfere with the right of others to use and enjoy their property. An owner's use of their property often creates some degree of inconvenience for the occupants of neighboring properties. However, to constitute a nuisance, the inconvenience created by an owner's use needs to be serious enough to be an improper interference with another's use and enjoyment of their property. So, for example, the reason why I brought up the swimming pools earlier was if you don't properly tend to a swimming pool, it can turn green. Mosquitoes can end up causing an issue. This is one of the reasons why so a nuisance is something that is not just a natural hazard disclosure. A natural hazard disclosure would be, anyway, we already covered that in another chapter. I don't need to get way off into the woods. Balancing rights, inconvenient or improper. To determine whether a nuisance exists, when an activity is not classified as a nuisance per se, a balancing of rights on the neighboring property owners is applied. Every owner is entitled to use their property for any lawful purpose. However, an owner is limited in their conduct since their permitted use may not unreasonably interfere with the rights of others to use and enjoy their property. An owner's use of their property often creates some degree of inconvenience for the occupants of neighboring properties. However, to constitute a nuisance, the inconvenience created by an owner's use needs to be serious enough to be an improper interference with another's use and enjoyment of their property. Public versus private nuisance. A nuisance may be a public nuisance, a private nuisance, or both. A public nuisance is a nuisance which affects an entire segment of the public, such as a neighborhood. Nuisance versus trespass. Stopping a public nuisance is the responsibility of state or local government authorities. Officials may seek to abate or enjoin the nuisance, recover money damages, or bring criminal misdemeanor charges against the offender responsible for the nuisance. A private property owner may not stop a public nuisance unless the public nuisance especially obstructs the owner's use of the property, making the interference a private nuisance as well. For a private owner to abate a public nuisance by an injunction, they need to sustain injuries to themselves or their property, which are different kind from the interference or injuries sustained by the public at large. Remedies of suppression of money. Oh my goodness gracious. Remedies of suppression of money. The remedies for a public or private nuisance are an abatement by suppressed or termination of the interference, and an injunction and money losses in a civil action. An owner has the right to take self-help actions to end a private nuisance affecting their property if they can do so without creating a disturbance of the peace or causing injury. For instance, self-help abatement of a private nuisance typically occurs when the owner cuts off the limbs of a neighbor's tree which encroaches onto their airspace of their property. A civil action to end a nuisance involves seeking an injunction to stop the activity or condition creating the nuisance, money losses from those responsible for the nuisance, or both. The money losses an owner seeks to recover for a neighbor's nuisance are based on either actual money losses for injury or loss of value to the owner's real estate, or for injury to the owner, or intangibles such as emotional distress and personal discomfort. Permanent or continuing nuisance. The type of money losses an owner can recover for property damage caused by a nuisance depends on whether the nuisance is permanent or continuing. A permanent nuisance exists when the nuisance cannot be abated at a reasonable cost and by reasonable means. Conversely, a continuing nuisance exists if the nuisance can be reduced or terminated at any time at a reasonable expense. The money losses inflicted by a permanent nuisance are determined at the time the permanent nuisance is created. Losses afflicted by a continuing nuisance are limited to the actual injuries suffered prior to termination of the nuisance. Zach Bach, pipe it, sir. I am recording right now. I'm live on Facebook. Thank you. Permanent nuisance remedies. A permanent nuisance cannot be abated at a reasonable expense or by reasonable means. Thus, an owner's only remedy is a recovery of money losses. The money losses are calculated based on diminished value of the owner's property caused by the nuisance. For instance, a building on a neighbor's property encroaches on the adjacent owner's property. The encroachment is a permanent nuisance since it is perpetually obstructs the use and enjoyment of the owner's property and cannot be removed at a reasonable cost to the neighbor. In balancing the rights of the adjacent owner and the encroaching neighbor, the cost to the neighbor to abate the nuisance by removing the encroaching improvements far exceeds the loss of the owner's use. Thus, the owner is entitled to monetary compensation for the lost use of the portion of their property hindered by the encroachment, but cannot abate the encroachment itself. Continuing nuisance remedies. In the case of permanent nuisance, an owner can recover money losses equal to permanent decline in the property's value caused by the nuisance. However, recovery by a continuing nuisance cannot include lost property value since the nuisance can be entirely eliminated. The condition causing the diminished value will no longer exist once the nuisance is removed. Thus, no permanent loss in value occurs to be recovered. The primary remedy for continuing nuisance is an abatement to remove the nuisance or an injunction ordering the nuisance to be stopped. In addition to an injunction, other money losses which can be recovered by the owner are limited to the lost use of the property until the nuisance is abated, such as rental value, the costs incurred to remedy the damage done by the nuisance to the owner's real estate, the cost of cleanup or repairs necessary to eliminate the nuisance, and any expenses incurred due to personal injury or emotional distress caused by the nuisance. Statute of limitations on recovery. Under the statute of limitations, an action or a permanent nuisance is required to be brought within 3 years after the nuisance becomes permanent. In the case of a continuing nuisance, a new cause of action accrues and the 3-year statute of limitation begins to run anew, and each day the nuisance continues, or when the further damage is inflicted on the property. Chapter 44, Fin, moving on. Chapter 45, Boundary Disputes. Doctrine of agreed to boundaries. Consider a parcel of real estate divided into 2 equally sized parcels by a recorded survey. Later, a fence is erected between the parcels but not located on the common boundary line, causing one parcel to appear physically larger than the other. Multiple years later, the owner of the smaller parcel sells their land. The new owner hires a surveyor to determine the location of the boundaries between the properties. The survey sets the boundary at the location described in the recorded documents. The survey shows the fence is not located on the legally described boundary between the adjacent properties. The new owner of the smaller parcel seeks to recover possession of the land between the fence and the boundary. The neighboring owner of the larger parcel claims the fence is the agreed boundary, since it is reasonable to infer the previous owner agreed the location of the fence to be their common boundary. The owner of the smaller parcel claims the agreed boundary doctrine does not apply, since a recorded legal description of the boundary is available and the true boundary is thus known and can be located. Is the owner of the smaller parcel correct in relying on the legal description on the property to establish the actual boundary location? Yes. The doctrine of title by agreed boundaries, commonly referred to as the agreed boundary doctrine, does not apply, since the exact boundary location can be readily located, and the owner of the larger parcel defending the fence as the boundary cannot show the prior owners were uncertain to the true boundary description, and then, to resolve their uncertainties of the location, agreed the fence would mark the boundary. Holy smokes. Okay, so if you're just tuning in on Zoom, Andres is, of course, doing a wonderful job translating this into Spanish, I imagine, which is very difficult, right? But at the end of the day, all of these tests are available to be taken in Spanish. The books are available in Spanish, and the tests are open book. So don't beat yourself up if you're trying to write all of this stuff down. You can, of course, purchase the books at calpaces.com using the discount code 6106. So if you're just tuning in, that's the way to keep up. If you're watching in Zoom, feel free to ask any questions that you may have in the chat, which I can see is already open. Okay. Yep, and then we will go ahead and get to your questions at the end of class at the 5-minute warning, and then move on to Commission Bootcamp at 10 o'clock. The office is filling up, of course. Lots of people are in here. This used to be just me alone in here for Commission Bootcamp, or excuse me, for the real estate school from 9 to 10 and then 4 to 5. So I appreciate everybody sharing the office space here, making this possible. Okay, elements of ancient doctrine. To establish a boundary line under the agreed upon boundary doctrine, the following facts need to exist: uncertainty as to the boundary exact location, an agreement between the owner to set the boundary line, and acquiescence to the boundary line for a period of at least 5 years, or a substantial loss would be suffered due to the change in the location of the boundary line to the legally described location. The agreed boundary doctrine was developed during a time when less advanced surveying techniques made it too difficult or expensive to locate the boundary line described in the deeds. Thus, the more practical way to set a boundary line in rural and relatively unpopulated areas was often for owners of adjacent parcels to agree between themselves on the location of a common marker, such as a fence, to set the agreed boundary. However, surveying techniques have significantly improved. Now, if a deed is clear and a competent surveyor is available, the true boundary line can easily be established to eliminate uncertainty of the boundary's location. Thus, the ancient agreed boundary doctrine has been reduced to the status of legal last resort. However, in the absence of an oral or written agreement between an owner and their neighbor to set the boundary line at some place other than the documented deed line, the boundary line described in their deeds remains as the boundary. Agreeing to the boundary. Once owners of an adjacent property, uncertain over the true boundary, agree to establish the location of their common lot line, the location they set replaces the legal line, provided either a 5-year statute of limitation is run or a substantial loss would result from the boundary line being moved to the legally described location. Uncertainty over the exact location of a boundary line may arise in a number of circumstances. For example, where natural markers, such as trees, boulders, or a creek, were used to mark a boundary line, the location of the markers may have changed or disappeared over time. Section posts and other surveyor monuments which indicate boundary lines are also subject to earth movement, climate change, and human activity. Also, the legal descriptions for parcels of real estate may be conflicting or simply fail to correctly set a boundary line, or may not coincide with another line or boundary. An actual dispute over a boundary's location need not exist between the owner of adjacent parcels. Instead, owners are merely to be in doubt over the location of the true boundary and agreed to the location of the boundary when they set it. Usually, it is not the original boundaries owners, Usually, it is not the original owner who has a dispute over title or possession based on the agreed to boundary line. It is the later owners. However, when the boundary line in a recorded deed is readily ascertainable by a surveyor, the description in the record controls unless the landowner defending the location of the line as the common boundary provides proof the boundary lines as located settles an actual, not implied, boundary dispute. Agreement to make certain. An agreement to mark a boundary line may be oral, written, or result from the conduct of neighboring property owners. Oral or written agreements on the boundary location are called express agreements since they are not implied. Written agreements are the most efficient since they formally document the mutual intentions of both owners. However, they usually exist only in the case of lot line adjustment maps. However, unlike the conveyance of real estate, owners do not have to put their boundary agreements in writing for it to be enforceable. With the setting of an agreed boundary, neither owner is conveying real estate to the other. Instead, the owners are agreeing to what land constitutes their own property. The element duration. Owners need to acquiesce to the agreed boundary for a period of at least 5 years. The 5-year period is the statute of limitations for the recovery of real estate. The statute of limitations requires the adjacent owners to resolve a dispute within the 5-year period. If disputes are not settled within the period, the claims are put to rest. Thus, an owner who fails to object to a boundary dispute during the statute of limitations period is presumed to have agreed to the boundaries set by the adjacent property owner. However, an exception to the 5-year rule arises if the substantial loss will be caused by the movement of the agreed boundary to the true lot line. Limitations of the doctrine. The agreed boundary doctrine has limitations. The doctrine cannot be used to convey property. Further, the agreed boundary doctrine can only set a boundary the exact location of which is unknown to the adjacent owners without a survey or litigation. Any attempt to convey a portion of the lot to the owner of an adjacent property by use of the agreed boundary doctrine violates the statute of frauds, which requires a writing documenting the intent to convey land. Thus, the agreed boundary doctrine cannot be used to make lot line adjustments, in which adjacent owners move an existing line, the location of which is known only to them. Chapter 5 in the books, Chapter 46, a deed as transfer. A deed by any name is a grant. Real estate is conveyed when title is transferred from one individual to another. The transfer of an interest in title to real estate containing in writing is called a grant of conveyance, no matter the form of writing. A deed is itself the grant which transfers title of property. Title by deed passes either. Title by voluntary by agreement with the owner. Excuse me, I'm going to drink a little bit of water. I am this is like the most boring stuff on planet Earth. Holy smokes. Holy smokes. Here we go. Okay. Waking up. All right. Right, Andres? Here we go. Title by deed passes either voluntary by agreement with the owner, as in sell in the open market, or foreclosure on a trust deed or assessment bond, or involuntary without agreement, such as the enforcement of a creditor's judgment or tax lien. No matter the form of writing, the individual conveying real estate is called the grantor. The individual acquiring is called the grantee. Ownership of possessory interest in real estate include a fee simple, a life estate, a leasehold estate, and an estate at will. Fee simple ownership is presumed to pass by a grant of real estate, unless a lesser possessory interest is stated, such as an easement, life estate, or leasehold interest. A fee simple interest in real estate is the absolute ownership of the possessory rights in the real estate for an indefinite duration, creating a valid deed for conveyancing. To be valid, a deed needs to be in writing, identifying the grantor and the grantee, containing a granting clause stating the grantor's intention to convey, adequately describe the real estate involved, be signed by the grantor, and be handed to and accepted by the grantee on horseback. I'm just kidding. That was for anyone that was paying attention. Form deeds used in real estate transactions conform to these validity requirements by containing words of conveyance and contain provisions for the identification of the parties and a description of the real estate. They are also suitable size and format to the document to be notarized and recorded. A deed in writing with exceptions. To be valid, the transfer of ownership interest in real estate needs to be in writing, except for an estate at will or a lease for a term not exceeding 1 year, an executed, partially or fully performed oral agreement under which the buyer takes possession of the property and makes payments toward the purchase price or makes valuable improvements on the property or adverse possession. An executed oral agreement for the transfer of real estate ownership will be enforced either under the doctrine of specific ownership or estoppel. The application of both doctrines is unaffected by whether the property is being sold under an oral agreement to a buyer for consideration or given to a donee by gift. Title by claims of adverse possession. I'm barely reading this in English, Andres. I don't know how you're translating this in Spanish, but we're in it together. Here we go. Title by claims of adverse possession. To establish title by adverse possession, an occupant needs to show their possession is based on a claim of right or color of title. They have occupied the property in an open, notorious way, which constitutes reasonable notice to the recorded owner. Their occupancy is hostile and inconsistent with the owner's title. They have been in possession for a continuous and uninterrupted period of at least 5 years. They have paid all the taxes assessed against the property during their occupancy. An occupant's ownership by adverse possession based on a claim of right avoids the statute of frauds writing requirement. To obtain title by adverse possession based on a claim of right, the occupant has, by nature of adverse possession, no written documentation or evidence of title. Essentially, the adverse possessor is a trespasser in possession of the owner's property without any good faith belief they hold title to the property. Thus, in the case of adverse possession by claim of right, the owner of the property has not orally conveyed title to the real estate to the occupant. The occupant is a trespasser until the conduct on the property, time in possession, and payment on all property taxes meet the requirements for them to obtain a court-ordered transfer of title by adverse possession. Alternatively, title by adverse possession based on color of title usually occurs when the occupant's title is based on a defective deed. Grantor qualifications is capable. A grantor of property needs to be capable of conveying interest in real estate at the time the deed is signed for the deed to be enforceable of conveyance. To be capable, the grantor at the time of the deed is signed needs to be of sound mind, possess their civil rights, and be an adult of at least 18 years of age. However, an exception exists to the 18 years or over age qualification. An emancipated minor is considered an adult capable of transferring an interest in real estate. Grantor identification in deed. The grant provision in a deed needs to identify each person who is conveying an interest in the property. If a conveyance, such as a deed, is signed by a person who is not named as the grantor, the deed does not convey that person's interest in the property. The identity of the grantor by the provision containing words of conveyance needs to be determined by an examination of the entire deed, not just the signatures. For example, a deed identifies several individuals as grantors in the grant provision, and the document contains their signatures. However, the list of grantors named in the deed's grant provision is incomplete to convey full title. Several unnamed individuals also have an ownership interest in the property. Further, the signatures on the grant deed include all of the individuals who are co-owners of the property, even though some are not named as grantors in the grant provision. In this instance, the deed transfers only the ownership and title held by those owners named as grantors in the grant provision in the deed. The deed, by its wording, does not show the necessary intent to convey title by the unnamed owners who are not listed as grantors and also sign the deed. On recordings, the county recorder will only index as grantors those persons listed in the grant provisions, since only they conveyed their interest in the real estate. The grantee as any person. While the grantor needs to have the capacity to convey title, any existing person, individual, or entity may take and hold title to real estate as the grantee. A child or an incompetent person has the capacity to receive and hold title as the grantee, even though that person does not have the legal capacity to convey the same property. A deed needs to identify the grantee. For example, a seller accepts a buyer's purchase agreement offer. The seller concurrently signs a deed and hands it to the broker as the seller is leaving the country. However, the space for the name of the grantee is left blank. The broker is not instructed to enter the buyer's name as the grantee. The broker, as instructed, delivers the deed to the buyer without entering the buyer's name. This is an example of a grant deed. Okay, grant deed is the deed which does not name the grantee. Oh, excuse me. Is the deed which does not name the grantee a valid transfer of title? No! I just was waiting to hear Andre scream no in the back in the other office. A deed which does not identify a grantee is void. The identity of the grantee needs to be sufficient to identify with certainty the individual to whom the seller intends title to be passed. Additionally, a deed is considered valid if the individual identified as the grantee takes title under a fictitious name by which they are also known or have assumed for the purpose of receiving title. However, if the fictitious name is established for the purpose of committing a fraud against the grantor may set aside the deed as voidable. Sometimes, an unintentional error misnames the grantee in a recorded deed, such as a misspelling the grantee's name. A deed with a misnamed grantee is still a valid conveyance of real estate. Another deed from the same grantor to the grantee's name with the correct spelling of the grantee's name will not correct the error, nor will a re-recording of the original deed with an amendment containing the grantee's correct name. The recording of a corrected deed falls outside the chain of title in the grantor-grantee index, since the grantor no longer has any interest to convey. The grantor has already conveyed their title, albeit to a grantee, with an erroneously spelled name. A grantor who has conveyed the title cannot do so again, even as an attempt to convey title to the same grantee. Editor's note. I was trying to decide if I wanted to read it. Title companies are only concerned the grantor on a deed is the same person who took title under the incorrect name. Title companies will generally accept a deed conveying title which identifies the grantor by both their correct name and the incorrect misspelled name under which they originally took title as a grantee. Words of conveyance for a fee or less. The actual words of conveyance in a deed depend on whether the deed used is a grant deed or a quitclaim deed. A grant deed is used to pass a fee simple interest in real estate from the grantor to another individual, unless a lesser interest is stated in the deed. While no precise words of conveyance are necessary, use the word grant in the granting clause without noting a lesser interest in the description of the property indicates the conveyance of a fee simple interest in the described property. Alternatively, a quitclaim deed is intended to convey whatever interest, if any, the grantor may hold in the real estate. The words of conveyance historically used a quitclaim deed are remise, release, and otherwise quitclaim. However, only the word quitclaim is required as the word of conveyance. The word grant is not used in a quitclaim deed, since no implied warranties are included with the conveyance under the quitclaim deed. However, the parties to a quitclaim deed are referred to as the grantor and the grantee, describing the property conveyed. A deed conveying the property needs to be sufficiently described. I apologize. A deed conveying property needs to be sufficiently describe the property being conveyed. The description in the deed is necessary so the property can be reasonably located. If the property cannot be located from the description, the conveyance is void. The description of a parcel in a deed needs to be sufficient to allow the real estate conveyed to be identified and located with reasonable certainty by a surveyor. Facts not stated in the deed, known as intrinsic evidence, may only be used when an ambiguity arises as the description of the property conveyed. However, the intrinsic evidence may not be used to supply the deed with missing description or correct a defective description. For example, real estate is conveyed by a deed describing the property as the Occidental Mill Site, containing 4.95 acres being a fraction of lot 2. The use of the real estate's common name in the deed is sufficient to locate the boundaries and identify the real estate being conveyed. Additionally, a deed which describes real estate by street address, such as 879 Riverside Avenue, Riverside, California, 92507, will be considered sufficient to identify the real estate located at the street address, sometimes called a common description or common address. However, the deed best includes the property's legal description or map designation, such as a parcel or lot number, which contains the metes and bounds description needed to locate with certainty the parcel being conveyed. Thus, the real estate can be described by reference to other documents, such as a subdivision map, as it contains the metes and bounds description of the parcel. The document referenced in a deed is incorporated into the deed of the source of the metes and bounds description of the property conveyed. The grantor's signature. To transfer real estate by deed, the deed needs to be signed by the grantor named in the deed. A deed can also be signed on behalf of the grantor by the grantor's agent if the agent is authorized in writing to convey the property on the grantor's behalf. The agent is called an attorney in fact and is operating under a power of attorney. Additionally, a deed can be signed in the name grantor by an amanuensis as orally instructed by the grantor. Did I nail it? I think I got it. Did I say it in Spanish? An amanuensis is an individual who has the oral authority of the grantor to sign a grant deed by their own hand of the behalf of the grantor, unlike an attorney, in fact, who is an agent with the discretionary authority to determine whether they are to enter into a deed without prior approval from the grantor. This word, again, has a purely ministerial duty. You know what, this paragraph, I've had enough of you, paragraph. This is the first paragraph. I'm just gonna tap out. I've tapped out, paragraph. You can have that one book. Chapter 46, we are freaking done with you. I've had it with your noise. That was ridiculous. That was absolutely ridiculous. Preposterous. Okay, we're reading a 323 today. We might get pretty close to getting this done. Just skip more preposterous chapters. Chapter 47, grant deed versus quitclaim deed. The granting clause. Two types of deeds are commonly used to convey a real estate interest. These are grant deeds and quitclaim deeds. To pass a fee simple interest in real estate, only the word grant needs to be used in the conveyance. No other precise words of conveyance are necessary in a deed to convey a fee simple ownership. The word grant contained in the conveyance provision in a grant deed indicates the conveyance of a fee simple interest to another individual, unless the deed states a lesser interest is conveyed. A quitclaim deed customarily uses the word remise, release, or quitclaim, but does not contain the word grant. However, only the word quitclaim needs to be used to convey all interest held in the property by the grantor. A quitclaim deed conveys only the grantor's interest in a property, if any exist. A quitclaim deed can also be used in lieu of a grant deed to pass fee simple in the described real estate. The words used to convey property are evidence of the property. Oh my gosh, 6 more minutes, Serpa. Hold it together. Hold it together for all of us. A quitclaim deed conveys only the grantor's interest in the property, if any exist. A quitclaim deed can also be used in lieu of a grant deed to pass fee simple in the described real estate. The words used to convey property are evidence of the future role an individual conveying title undertakes after the deed has been signed and delivered. Thus, to convey real estate with covenants relating to the interest conveyed, a grant deed is used. To simply convey any interest in real estate without an assurance the individual holds that interest conveyed, a quitclaim deed is used. Grant deed covenants are implied. The covenants, sometimes called warranties, implied in a grant deed include: the interest conveyed in the real estate has not been previously conveyed to another except as disclosed in the grant deed, and the real estate has not been further encumbered by the grantor except as disclosed in the grant deed. Grant deed covenants are implied. Thus, they are not separately bargained for as provisions to be included in the grant deed conveyance. If a grant deed covenant is breached by a grantor, seller, the grantee buyer, may recover their money losses from the grantor for the breach of the implied covenant, as though the covenant had been written into the grant deed. The covenant against encumbrances. Real estate encumbrances include taxes, assessments, conditions, covenants, and restrictions, CC&Rs, and all liens, voluntary or involuntary, attached to the real estate. Encumbrances are the subject of the implied warranty against encumbrances in the grant deed, since they burden title and appreciate its value. Quitclaim deed. This is an example of a quitclaim deed. For example, encumbrances include CC&Rs such as the use restrictions running with the land, building restrictions, a reservation of a right-of-way, an easement, an encroachment, a lease, and a pending condemnation action. I feel like just intentionally. Covenants are restricted, limited, to avoid the liability harassment of the covenant of the grant deed, the liability of the state of the title of the condition covenant. We've got 3 more minutes. All right. Covenants, restricted or limited. To avoid liability arising out of the implied covenants, a grant deed needs to be the state of the title conditions encumbrance created by the seller during the ownership. These conditions are or are not agreed to by the buyer in the purchase agreement. The implied covenants in a grant deed are waived by the buyer and do not apply when the seller and buyer agree to the contrary in the purchase agreement. In this instance, the buyer and seller list all of the title changes made by the seller in the grant deed. Covenants personal to grantor and grantee. Implied covenants are only for the personal benefit of a buyer, not future owners, referred to as remote grantees. The implied covenants in a seller's grant deed to a buyer do not impose a condition on title and do not run with the land. Thus, being personal to the seller and buyer, the implied covenants in a grant deed may only be enforced by the grantee named in the deed. Implied covenants cannot be enforced by the future remote grantees who acquire the buyer's interest at a later date. Conversely, covenants running with the land, such as CC&Rs and easements, bind all future owners, remote grantees of the property. Covenants running with the land are binding on future owners, whether they take title by deed or court order, as covenants running with the land affect title. For a covenant to run with the land and affect all remote grantees, the seller creating the covenant to the land, to the state, in their covenants is that successors, remote grantees, are bound by the covenants and restrictions imposed on the property as contained in the deed. We have 9 more pages, which we are not going to get to because we are done. Let me tell you a little bit really quick about what we got going on. Reset the class a little bit. Give yourselves a big pat on the back. We made it through another day. Give yourselves a hug. Holy crap, we made it. That is awful. All I could think about was a Popeye's chicken sandwich the whole time and how bad I feel for Andres trying to translate this into Spanish. It was rough. So listen, you do not have to sit through all of these live every day. I appreciate the 6 of you being here on Zoom. I appreciate the 2 of you who are the last 2 standing on Facebook. I appreciate everybody watching on YouTube. If you're in California, you can start working towards commission starting here in 5 minutes. You do not have to be licensed. You just need to be able to find and identify people who are interested in buying and selling real estate. We already have it happening. Lika called me yesterday with somebody, a military veteran, Air Force veteran, who we booked an appointment with on Tuesday. He's going to get out and start looking at some real estate out in Menifee. So if you want to buy and sell real estate, feel free to reach out to our community directly, of course, but that's not why we're watching this video, so my brain is turned off. If you want to get into real estate, feel free to reach out to us directly, and we'll be happy to set you up, our friends, and welcome you into the family. Feel free to reach out to me directly. My number is 951-691-7798. I'll tell you about what we got going on here at our community, how you can jump in on day one without a real estate license and start earning commission as a finder. Everybody have a great day. I'm going to cut this loose now so that we can start Commission Boot Camp right now. But on Zoom, if you have any questions, ask, and I'll hold on and I'll wait for you guys. Killing the Facebook feed. Adios, Facebook. Adios, YouTube. Okay.